Welcome. Thank you all for being here this afternoon. My name is Carrie Burns. I'm Chief Strategy Officer at the Bar Association, and welcome to our discussion this afternoon on the removal of prosecutors from office. You're going to hear from our presenters today about this topic, why it's new, why it's not new, what's happening, and what we can do moving forward. But first and foremost, I want to give some CLE information because that is what you're here for. Please make sure that you have your video up and your audio on. Make sure you can see and hear us the entire time. We do have to administer a poll during this program. So Mark and Lou, it's going to pop up on your screen, just X out of it. But for everyone else, please respond to the poll so we can tell the court that you were here and paid attention. Finally, at the end of the program, you will get a survey emailed to you. Please make sure you fill out that survey. That is how we report to the court that you were here. We are also going to take questions today. Please use the chat or the Q&A feature at the bottom of your screen. We're going to take questions at the end. So as you hear the speakers present, and you have something you want to ask, please put it in there and we'll make sure to get it to them if time allows. And with that, I would like to introduce both of our speakers today. First, we have Mark Levin. He began the Texas Public Policy Foundation's Criminal Justice Program in 2005, and in 2010 developed the concept for the Right on Crime Initiative, to which he serves as senior advisor. Levin was named to the Politico 50 and has testified frequently on criminal justice policy before Congress and state legislatures. Levin received his undergraduate and law degrees with honors from the University of Texas and clerked on the Fifth Circuit Court of Appeals. Thank you, Mark, for being here today. And Louis Tobin, he is the executive director of the Ohio Prosecuting Attorneys Association. Prior to his current position, he was deputy director of the Ohio Judicial Conference, where he worked for 7 years in various legislative and judicial service positions. Prior to his time at the conference, Mr. Tobin worked as a legislative aide for State Representative Linda Bolin in the Ohio House of Representatives. Mr. Tobin holds a Bachelor's of Arts in Psychology, cum laude, from The Ohio State University and received his JD from the University of Pittsburgh School of Law. So thank you, Lou, also for being here this afternoon. And so what we want to do, Mark, I want to start out just talking about why are we here today? Why are we talking about this? I came to you originally because of a headline you wrote probably back in August. And so it piqued my interest, and I think some others here today. So please kind of give us the background of the removal of prosecutors from office.
Sure. Well, it's great to be part of this discussion and appreciate all the work that's being done in Ohio. Ohio has really made some important reforms in recent years, both to enhance public safety and to improve the fairness of the justice system. So, you know, it's what we've seen is the role of prosecutors has really become more highly scrutinized in the last several years. And there are certainly some differences in terms of what people want to see in prosecutors, but you know, there's also a commonality, I think, in that it's been recognized that the role of a district attorney and their line prosecutors is more than just processing cases, but really to also serve as a minister of justice and to concern themselves with the outcomes. Does, after they prosecute a case, let's say a low-level drug possession case, does that individual a few years from now will they do better if they went through a drug court, if they were diverted entirely from the justice system, or if they were sent to prison? And for a prosecutor, whether through some are now using dashboards or other ways to keep track of the outcomes of the cases, and also, of course, how victims, whether they're satisfied, whether they get restitution in property cases, for example, and certainly using feedback from victims, whether it's to a form or otherwise, about in property and violent crime cases, did they get the services they were hoping for to deal with their trauma? So there's all these different ways prosecutors are, I think rightly, across the spectrum, seeing their role as, really as being, as I said, ministers of justice being very important. Processing cases efficiently is a very critical part of that, but it's also just one piece of it. Where we've gotten into more controversy, I think, is the question of, you know, not prosecuting certain categories of cases. And that's something I know we're going to get into more as we go on. But I think it's great that we're having kind of more public attention on just how important the role of prosecutors really is in our society.
Thanks, Mark. And Lou, we wanted to talk about, as we start to go deeper into the details and get more granular on this, the progressive prosecutor. And so we've seen the headlines with Dobbs and with the Philadelphia DA, you know, they're headline grabbing, and this progressive prosecutor is the label. So can you talk a little bit more about that?
Yeah, I think, first of all, a couple of things. I think what really generated this most recent discussion about prosecutor removal from office obviously was the Dobbs decision. And I think people were understandably upset about Dobbs, but I've never gotten a question from the media before about whether prosecutors are going to enforce a law that the legislature has passed or not. I mean, think about how strange it would be if the media were to call me and say, hey, are prosecutors going to enforce this new domestic violence law or this new law about carrying weapons under disability? So it was really strange to get that type of question. I think despite how people might feel about Dobbs. And I think just quickly background about the OPAA, because I think it's important to understand for this discussion that, we're a nonpartisan organization. We have members who are on both sides of the aisle. I think members who feel strongly probably about the Dobbs decision on both sides. But as a nonpartisan organization, I've tried to keep us out of these politically hot button issues, I think, in the General Assembly. For one, because there's just not consensus amongst my members, and two, because I think it tends to suggest that we are somehow a partisan organization and we have to be able to work with both sides of the aisle. So I think when I started to get questions about this from the media, my answer was, look, I think prosecutors are going to do what they do in all sorts of situations. Now they're going to have to evaluate any evidence that's presented to them and decide whether and how to use the resources of their office to achieve a fair and just outcome. But I think, that it's important to understand the background of why that question is being asked. And that gets to the heart of these quote unquote progressive prosecutors that you're asking about. Some people call them progressive prosecutors in criminal justice circles. Other people in criminal justice circles call them rogue prosecutors. From my point of view, what they really are is just kooky. It's people like Larry Krasner in Philadelphia, George Gascon in Los Angeles, formerly Chesa Boudin, who was removed from office in San Francisco. And what I think progressive isn't the right label, because it's not that they're Democrats. It's not that they're proactive about some of the things that Mark was talking about. We've had prosecutors in the state of Ohio who have been on the ground floor of creating prosecutor diversion programs and intervention in lieu of conviction programs and record sealing to help people get back on the right track. What the quote unquote progressive prosecutor is really somebody who I think distorts what the role of the prosecutor is in the criminal justice system. And essentially usurps some of the legislative authority about what laws they're supposed to enforce and what laws they won't. I think you'll see what you see is them deciding not to enforce entire categories of cases rather than analyzing situations on a case-by-case basis, depending on the individual facts of a case. And I think that's what the progressive prosecutors really do. And I think that's kind of the background. That's why I think the conversation about prosecutor removal exists, because for good or for bad, I think certain conservative politicians are concerned that the laws of their legislatures aren't being enforced, one, and I think two, I think they see some political opportunity in attacking what they view as soft on crime prosecutors.
Mark, do you have anything to add to that portion of it?
Well, certainly. I mean, I think there's definitely, and you made some important distinctions there. I think that, certainly my view is that the prosecutor should look at every report that comes over from the police, and a lot of times the offense may be the same, but the background to it might be very different, including whether the alleged perpetrator has a history, especially a recent history of more serious offenses. And so I think some of the announcements that were made by certain elected DAs did make clear that they were just establishing a presumption or default that they wouldn't prosecute certain categories of cases, which were usually things like, public trespassing. So for example, in Dallas, John Creuzot said he would have a presumption of not prosecuting public trespassing, although someone sleeping in the rail station, but he would continue to, generally prosecute private trespassing, someone on your property. So, but he would still look at every file that came across his desk. Some of the announcements were, and then of course there's the whole issue besides whether the announcement kind of makes clear that you'll still look at every file. There's the question of, some people argue simply making these announcements is problematic, but I think that's, there's a tension with also the fact that we are talking about democratically elected prosecutors. And so, for example, Rachel Rollins in Boston and several others, they ran on this. They told the voters, I was going to establish a presumption of not prosecuting these categories of cases. And then we kind of like to praise politicians or elected officials, in this case at least, for doing what they say they're going to do. Now, she ended up paring back some of what her initial pledge was. And, I think the other thing that's really part of this is prosecutors do need to try to work collaboratively with sheriffs, with judges, with treatment professionals, with a whole range of stakeholders. And I think the key is putting in place a set of alternatives that everyone can have confidence in, particularly for these low-level cases, especially involving people with mental illness or substance use disorders, people who have an overdose, aren't involved in dealing drugs, people who have a mental health breakdown. And because I've heard over the years, especially in Texas, this was before we implemented more alternatives, but it was common to hear from, and it's still an issue, but from prosecutors and even judges saying, the reason we had to get this guy a conviction was to get him into treatment. There was no funding for drug or mental health treatment unless we got him adjudicated and got him a conviction. So the prosecutor can work with these other entities and the legislature to actually appropriate the money for this. So, and get it ultimately kind of an MOU, a game plan, something memorialized in advance and says this category of people, we all agree are appropriate to be on this off ramp from prosecution very early in the process, so they don't sit in jail because they were, a mentally ill guy disturbing the peace, yelling at the top of his lungs at McDonald's. So those are kinds of the cases people can agree on and do it, in a coordinated way. And I really think that's ideal. But you have seen in some jurisdictions a lot of tension between elected DAs and elected sheriffs over some of what we're talking about here today.
And so you both have said at a certain point that this is political, and that's why we're here today too. And we started to talk about the tension between elected officials and the duties of a prosecutor. I have a specific question for you, Lou. Lawyers have ethical duties. And so one of those ethical duties is, and it's not specifically stated, but to uphold the rule of law. And if there is a law out there that states this is what it is, and you're a prosecutor, you have to uphold that. But like Mark was discussing, you have an electorate, you're an elected official as well. And so how do prosecutors toe that line when dealing with that?
Yeah. And I think it goes back to this idea of, what prosecutorial discretion is. I mean, look, Mark is right that some of these quote unquote progressive prosecutors have campaigned on this stuff and they've been elected. And, there's a famous saying that in a democracy, you get what you deserve. And I think actually, I've got a quote from H.L. Mencken that's even better, that democracy is the theory that common people know what they want and deserve to get it good and hard. So, there's some truth to the argument that this is what the voters of those jurisdictions wanted. That they get what they voted for. But prosecutors do take an oath to uphold the law. And so I think that's, they have to draw a fine line between the use of discretion and violating their ethical duty and their oath to uphold the law. And really what that entails is that this case-by-case analysis of, what did this person do? What's in their criminal history? What was the impact on the victim? What are the best roads towards justice and rehabilitation? And when you're making announcements and implementing policies that say you're not going to prosecute misdemeanor offenses, or you're not going to prosecute theft offenses, or you're not going to prosecute drug possession offenses. I think that's where these progressive prosecutors cross the line. So you do have to do that case by case analysis and use your discretion and your judgment that way.
Mark, anything to add to that?
Well, I think that we'd also, I mean, I don't disagree with that, but I also think we have to recognize the feedback mechanism here that, first of all, there's too many criminal laws. This is something I've written about for a long time, but at the federal level, Dick Thornburg, the late Attorney General under President Reagan, estimated there were over 300,000 federal crimes, counting all the regulatory crimes, in addition to the statutes. And in Texas, we counted a couple thousand, including, you know, thrashing a pecan tree. And obviously that's not what's driving the numbers in the justice system. But the broader point is that, you know, the obviously abortion added a whole new, and, you know, we all have different feelings about that topic, I'm sure, but it added a whole, and especially when you have abortion and drugs, and I'm not here to say hard drugs should be legalized, but when you have things that are consensual activities, that puts prosecutors in a more difficult situation, because you also have problems of getting people to testify. Now, one example that we deal with across many jurisdictions, you know, in Texas, marijuana is still a misdemeanor, even the smallest amount jailable by up to 180 days in jail. But in urban and even suburban areas, it's very hard to find juries anecdotally. And actually, there's even some academic research about this now that are willing to convict someone. So it's hard to fault a prosecutor for not pursuing those cases. I think that that it is a feedback mechanism, therefore, that the legislature needs to be more circumspect, and Congress, about what things they designate as crimes, and think about, could this be civilly you know, handled as a civil offense where somebody can file a lawsuit against somebody because of this conduct. And then obviously in the context of abortion, I mean, even a lot of pro-life leaders have said they don't want to see women prosecuted. And of course, when you talk about hospitals, or we pointed out in our article in Washington Monthly that hospitals and doctors, they have to maintain medical insurance. There are very few hospitals or doctors that are going to do something that's even a civil violation. So there's not a whole lot of enforcement that ends up being required. So, you know, I think that that to some degree, prosecutors across the spectrum kind of don't want to be settling things that are so politically divisive in the country, that they want to be focused on enforcing laws that are, you know, that most people agree that there's harm to another person involved, and we need the government to step in.
And to go back to something that Lou talked about, you know, there's discretion, and then there's an abuse of neglect. And what I find interesting, and correct me if I'm wrong here, but in some of the background research I was doing, these aren't disciplinary cases. You know, we're not talking about a prosecutor being removed because they violated some abuse of or extreme neglect or something like that when prosecuting a case. These are coming from the legislature. These are, especially the most recent ones, they're coming from other elected officials removing these people from their positions. And so, Lou, can you talk about a little bit the law in Ohio and what is the difference between discretion and neglect?
Yeah, so there are a couple of provisions in Ohio law related to the removal of public officers. There's, and I'm going to refer a little bit to my notes here. Article 2, Section 38 of our Constitution is removal for misconduct involving moral turpitude or for other cause provided by law. And then we've got a series of statutes, Revised Code 3.07 to 3.010, and that involves a refusal or removal for refusal or willful neglect to enforce the law or to perform any duty imposed by law, or gross neglect of duty, gross immorality, drunkenness, misfeasance, malfeasance, or nonfeasance. And then there's a provision that's specific to the removal of prosecutors here, and that's the removal for willful neglect of duty or gross misconduct. And so there's actually not a whole lot of case law on removal, particularly about the removal of prosecutors from office. I think for the most part, prosecutors are doing their jobs well. I think to the extent that their communities feel like they're not doing their jobs well, they're being voted out of office. I know some prosecutors have gotten themselves into some sort of trouble with the law. I think, you know, oftentimes when that happens, they'll resign before it gets to this removal stage. But there are a couple of cases that are relevant to that removal statute. And they really had to do with whether a prosecutor who declined to prosecute a case during one term was somehow obligated to continue to review that case and decide whether to prosecute it again, and whether that constituted neglect of duty. And basically what the court said is that there is no such obligation. That's not neglect of duty. I think what would amount to neglect of duty versus the use of discretion is if a prosecutor just sat on cases and did nothing, or decided that they weren't going to do anything about an entire category of cases. And here's what the court said in the one case on that is: a prosecuting attorney will not be compelled to prosecute a complaint except when the failure to prosecute constitutes an abuse of discretion. Therefore, the decision whether to prosecute is discretionary and not generally subject to judicial review. And then the United States Supreme Court has said with respect to federal prosecutors that so long as the prosecutor has probable cause to believe that the accused committed an offense defined by statute, the decision whether or not to prosecute generally rests entirely in his discretion. And so that's really the difference, is whether you're doing this case by case analysis or whether you're sitting and letting things linger on your docket and not doing anything about it, or purposely deciding that you're not going to prosecute certain entire categories. And I think, again, to go back to the progressive prosecutor, I think the problem for them is that they're not really worried in these certain categories of cases about whether there's probable cause and what they need to do to achieve justice for their community and for the victim and to rehabilitate the offender. They're just deciding that they're not going to do anything.
So we've talked about undercharging or not charging, but what about overcharging? Do we see the same reactions if prosecutors are consistently overcharging certain individuals?
I think we would. I don't think that we have, at least in Ohio, I don't think we have prosecutors who are doing that. I know that is a talking point. I think particularly for some people on the left, that we do have prosecutors who are throwing the book at people. I don't think we do. I think we have prosecutors here who are selective about the charges that they're bringing. They do recognize that they're ministers of justice and that they have responsibilities to treat the defendant fairly and uphold the defendant's rights, in addition to seeking justice for whoever the victim is and making sure that their community is safe. I guess to answer your question more directly, I think if there were a rash of prosecutors overcharging things, I think we would see complaints about that.
Sure.
Yeah, I think the concern that that I see across the country has to do with specifically what has been called the trial penalty, which is, over basically, I do think we need plea bargaining, but, we have, more than 9 out of 10 cases, of course, are plea bargains, so trials are quite rare now. And at least in some jurisdictions, this isn't Ohio, but studies on federal cases and in New York and California, they've shown as much as a 6 or 8 times stiffer penalty for people that exercise their constitutional right to go to trial. Now, I think some, you could look at it either way, right? It's a discount for people that plea. And I mean, look, there's people that get too generous a plea bargain too. But I think that, and there's a lot of factors, of course, if by virtue of someone not going to trial, in certain cases, that could mean a victim, even a child victim, doesn't have to go through excruciating process of testifying and so forth. But I think that if you look at other countries, for example, on plea bargaining, you generally see discounts of 20 or 30%. You don't see, exponential differences. And so we've seen cases where someone who's actually less culpable, and where there was multiple defendants, someone who was less culpable, but exercises their constitutional right to trial, played less of a role in the offense, ends up getting a much higher penalty. So I don't, certainly blame prosecutors personally for this. I think part of it is obviously the many prosecutors feel like there's not enough manpower, not enough they don't have enough staff to handle all, taking more cases to trial. And so there's, but there are instances where, for example, someone may be kept in jail and they really shouldn't be pretrial, and there's leverage there to get them to plea. There's been a lot of cases. We had a few hundred cases several years ago in Harris County where people pled to drug possession, and then when the powder came back from the lab, it was actually not illegal drugs at all, and they were in jail. They just pled to time served to get out of jail. So the combination of some pretrial, and I do think there's people who, and Ohio recently approved an amendment on this. There are people that absolutely that are high risk that should be denied bail no matter how much money they have. So it's really complicated. I think, prosecutors face, a difficult challenge trying to navigate all this with limited staff. But I do think we could use more transparency in plea bargaining. For example, letting the judge, or if the jury's doing the sentencing, see what plea bargains were offered in the case. I think that's one kind of measure to try to, have a little bit more, I think, fairness in the system.
I want to get back to national removal provisions, but Lou, did you want to respond at all to anything Mark just said?
The only thing I'll say is, and I don't want to veer too far into the plea bargaining discussion because I think that's a topic for another day, but, the plea bargaining in Ohio is already done in open court. The judge is already free to reject whatever plea bargain is offered by the state or agreed to by the state and the defendant. And I know that in general parlance, it is called the trial penalty, but there's something to be said for the fact that a person who is agreeing to take to a plea bargain is acknowledging their guilt, and they're acknowledging at least to some extent that they're remorseful. And a person who's going to trial isn't necessarily doing that. So it's not so much that a person is just going to trial. I think often part of the plea bargaining discount is the fact that they are remorseful and acknowledging that they committed the crime.
Thank you. Mark, I want to get back to our original discussion about removal provisions and what do they look like? Lou talked about in Ohio. What does it look like nationally in some different jurisdictions?
Well, it literally is all over the map. So some of our participants here may have seen where the Florida Governor Ron DeSantis removed Andrew Warren, who's now challenging that. He's was the district attorney or state's attorney, as it's called there in the Tampa, St. Petersburg area. And, there was a previous case there of state's attorney in Orlando a few years ago who was removed because she, also by Governor DeSantis, because she was unwilling to use the death penalty in any case, regardless of what the facts were. So that was upheld. The way it works in Florida is the state's attorney who's removed can challenge it both in the legislature and in court. But the Andrew Warren challenge is still pending, and there was some language in the judicial decision denying the other challenge I referenced that suggested that Warren's challenge might have more success. Warren really was not someone who had announced he was not going to prosecute certain crimes, and it's not exactly clear, all except for the abortion issue. Now that of course is might well be kind of the main thing that precipitated it. But so we'll see what comes out of Florida. But the other some of the other states, for example, in Virginia, you can start a recall, and there are recalls against a couple of they may call themselves progressive prosecutors, I imagine. And I don't like the language in the sense that certainly there's certainly a bucket of prosecutors who are kind of ones that were referenced earlier, but then there's certainly other prosecutors who have run on kind of reforms that have not kind of kicked up the same firestorm. So there's lots of different, I guess, but I'd like the word effective, are you effective or not, is really the question. But so there's Northern Virginia, a couple of them there are facing recalls. And then if you get 10% of the voters there, then a judge decides whether the prosecutor should be recalled. It's kind of a blended system, and it's very odd. I know some in the assembly in Virginia are trying to look at changing it. And then, of course, California, where, not only was Chesa Boudin recalled, but most people think that if the signatures, they were just short, that if there had been enough signatures, George Gascon might have been recalled, the prosecutor in Los Angeles. But of course, he'll face an election again relatively soon. I think that obviously a backdrop to this, in addition to abortion, is just the increase in crime, particularly homicides. And I think that the public is understandably frustrated about that. It is important to point out that this increase has occurred in jurisdictions throughout the country, both those governed by, conservative or traditional prosecutors, and liberal and progressive prosecutors and governors and all of that. But it's not to say decisions in particular cases. I mean, you can certainly find cases from many different jurisdictions, regardless of the politics, where somebody was, in retrospect, we all would say, I mean, the one in Milwaukee stands out, in Waukesha, where the perpetrator who ran over the people at the parade. And when you look back at that one in particular, you see that there was a problem with information sharing from Milwaukee to the suburban counties. They didn't all have access to the same data on this guy's prior record. And maybe even without some of that, I think John Chisholm, who's the prosecutor in Milwaukee, acknowledged in retrospect he would have made decisions differently. But it did just show we really need to have DAs across jurisdictions, across counties in a state, be able to access the same data, on somebody's criminal record and so forth, risk profile and all of that. So, but you can always find these cases where, in hindsight, everyone would acknowledge things should have been done differently on either side, because we've had people die in jail in the last year, some of whom looks like may have been innocent or were certainly in there for minor things and certainly didn't deserve to die in a county jail. And we've had this rash of deaths even after COVID. So there's people that should have been handled more seriously, and those that were dealt with too harshly as we look back on it. So having better data, being able to make better decisions, even though you're never going to have a crystal ball, I think is important.
If I could just add something to that, just to draw a little bit of a distinction with Ohio, and to, I think, talk a little bit more about what happened in Florida. I think it goes back to, I think, what generated the whole discussion after Dobbs about whether prosecutors were going to enforce abortion laws, and whether they're going to be removed from office. And what precipitated that was this letter from an organization called Fair and Just Prosecution, that, at least as of July, had been signed by 85 prosecutors from across the state, that they didn't think enforcing the abortion laws was the role of the prosecutor in society. And so that kind of led to the whole media uproar about this, in terms of how abortion laws related to prosecution. But I think, one of the things that I found interesting about the letter, and I went back and looked at this yesterday, is that of the 85 people or so who signed it, 50 of them came from jurisdictions where abortion rights aren't even under threat. Another one of them was a municipal prosecutor who has no jurisdiction to prosecute abortion as it is. And so you've got this group of prosecutors who there are no consequences for, saying, hey, we're not going to do this. And it puts some other people who are in Republican states, but in Democratic leaning electorate within that state, somebody like the prosecutor in Tampa, it puts them potentially in a bad position. And so I think what ends up happening is that Mark is right that not everybody is in the same bucket as Larry Krasner and George Gascon and Chesa Boudin, but something like that winds up putting them all in the same bucket, even though they're not. And I think one final point about that, just in terms of how that relates to Ohio, another thing to point out is that, In Florida, when Governor DeSantis removed Andrew Warren, DeSantis got to fill the position. He's responsible in Florida for the appointment. In Ohio, if a prosecutor is removed, the county commissioners fill the vacancy temporarily, and then the county party that nominated the person who held the office fills the position until for the remainder of the term. And so, if a prosecutor were removed here, the party from which they were elected is going to fill the position anyway. And so I think that's not that the legislature couldn't change that, but that's a little bit of a deterrent to a legislature or a governor just removing somebody from office here.
Yeah, and if I could just add, the just to illustrate kind of when pronouncements that kind of don't have nuance, they can, overlook, what are admittedly exceptional cases. But, there was this Dr. Kermit Gosnell, this is in 2013 in Philadelphia, but he performed illegal partial birth abortions at the time, babies born alive, but he was sentenced to a third life term in 2013, and that was obviously during Roe v. Wade being enforced and all of that, but they were gruesome. And it was something that obviously, you could call it an abortion, but you could also call it infanticide, given the facts of that particular case. And so, I think that on the other hand, obviously we know that, that basically I think there was a letter that was in the National Review from about 70 pro-life leaders that said we don't want to prosecute women and so forth. And states are obviously struggling to figure out what legal framework to put in place now. And I think prosecutors, my concern is that, whether it's in this area or, whatever the latest controversy is, are they going to get brought into the transgender issue or whatever it is, that people are so quick to say the solution is criminal penalties for everything, or on the other side to say there's never a role for to even look at exceptional cases where maybe it is in that case. But overall, I think generally the criminal law is a blunt instrument. It should be the last resort for resolving what are social issues.
Just one last thing on that, Carrie. And I think this relates to the uproar over the signing of this letter, and I think also the removal of Andrew Warren is this idea, in the law of whether there's actually a case or controversy or not. And I think Andrew Warren was making the argument that, look, yeah, I signed this letter, but no case has ever even been presented to me where I've had to decide whether to prosecute it or not. And so how can you say that I'm willfully neglecting my duties when nothing has even been presented to me? One. And I had another thought that just slipped my mind. So
it's a decent argument. And it's interesting because as we sit here, how long has it been since Dobbs? And sure, there's those 85 DAs, but there's more DAs who didn't sign the letter. And have any of them brought any prosecutions on abortion? I haven't heard about it, but there have been very few. It gets back to what I was saying earlier, hospitals and doctors that have licenses and have to keep insurance and all that. They're not going to do something that's now a crime in their state. And but on the other hand, you can send, there's a European company that's sending people pills in the mail. We'd have to have a much bigger government and law enforcement apparatus. And again, the backdrop to this is the increase in homicides and all these. We have pending, I read in Seattle, to deal with all the serious felonies backlog, it could take 10, 15 years. So, and we have backlog in Houston where I live that's very, thousands and thousands of felonies. So, just to do the bread and butter, the things that everyone agrees should be, the core of prosecution, we're not keeping up, partly because the court's being closed for COVID. So that's the backdrop to this. A lot of kind of theoretical discussions and that don't end up bearing out in reality.
and that was actually, you hit on the point that slipped my mind, was that doctors are solidly within the group of people who are going to be deterred from doing this, regardless of what a prosecutor does or doesn't say. And so, regardless of whether a prosecutor signed the letter or said they're not going to prosecute abortion, I think most doctors are going to be very reluctant to move forward with performing abortions in a state where they're risking potentially the loss of their law license or the loss of their freedom. Not law license, medical license.
Medical license. There's a question in the chat about this, and it was kind of percolating in my mind as well. But let's look at, we've been talking about abortion and Dobbs, but what about marijuana? I feel like that may have looked like Dobbs 10, 15 years ago, but when there's an overwhelming groundswell for support of something that may still be illegal or something that is able to be prosecuted, where do we go there? And I feel like now marijuana looks a lot different than abortion does, where it's being more widely accepted. It's being, states are passing these recreational use laws. But there was a time where in the federal level still, they say we're just not going to prosecute that. And that seems to be less of a debate than this abortion discussion. I don't know who wants to Mark, because you're the national guy.
Yeah, I mean, it's we still have in Texas, like 2 of the top 5 common reasons why people are arrested are marijuana and driving with a suspended license. So there are a lot of cases that, we do have a cite and summons law that I work with Governor Rick Perry and the legislature to put in place in 2007, that the officer has discretion to use a cite and summons instead of bringing the person to jail, so long as they live in the county and they don't have outstanding warrants and such. And it actually covers some other things too, like petty theft and so forth. And there's not really, you can't really find data, on how often it's being used. But I think that obviously so many states have just legalized marijuana, and actually there's a push here in the interim in the lame duck session in Congress for Safe Banking Act, because of course, maintaining all this cash and the marijuana stores makes them a target for burglary and so forth. I think it's a very sensible thing to do. And frankly, the federal, to say Rick Perry again in his book, said the federal government should just get out of it and let the states determine if they want to have it be a crime or not. It's still a Schedule I, drug at the federal level, higher than opioids. So it is. I will say that I think there are some health issues that it can obviously have both positive and negative effects, but certainly for people who use it to excess, particularly young people, there's some research suggesting it may have a negative effect on their brain development. But for other people, it relieves pain. But overall, I don't think it is distinguishable from some of the hard drugs in the sense that I don't think it's correlated with committing violent crime, for example, and people, typically don't have an instant overdose where they die right there from marijuana, that sort of thing. So overall, I think the effects of prohibition have, literally the cure has been worse than the disease. There's all sorts of things that have to be, provisions that need to be in place to have a legal market that really works. You want to make sure that the taxes aren't so high that you get a black market, but you also want to make sure that people get that they have confidence that whatever they're buying is not adulterated, that it's not synthetic marijuana and things like that. So there are challenges to decriminalization or legalization that have to be worked through. But overall, I think it's the better approach. But as far as prosecutors go, yeah, I think that there's not much appetite for prosecuting marijuana cases, even places where it's still illegal, and there's not much appetite among juries to see those cases.
Yeah, I would just add that I think in Ohio, the prosecutors in the law enforcement community think marijuana should be illegal. And there are a lot of them who would like to continue to prosecute those cases. That's not to say that you lock the person up and throw away the key just because they're in possession of some marijuana. But prosecutors and law enforcement are very concerned about the impacts of that on their communities and on society and on the individuals using it, just like they are with any other drug. But I think they face a practical problem here, that there just aren't enough resources to test most of the marijuana that law enforcement comes across on a daily basis. And so you wind up just not being able to prosecute most low level marijuana cases because there's just not there aren't the resources to figure out whether it's marijuana or hemp, which is legal here now. So that's one. And two, I would just reiterate what I said earlier is that I think regardless of a person's views on whether marijuana should be legal or illegal, public policy changes like that should be accomplished through the legislature, not through prosecutors. And to Mark's point earlier, you what you do is when you start putting pressure on prosecutors about these things, it turns into a slippery slope. What else are they going to come under pressure not to prosecute, or what are they going to come under prosecute to throw? Who are they going to come under pressure to throw the book at? That's the prosecutors aren't policymakers. They have discretion on a case-by-case basis to decide what's best and how to achieve justice. But I think to the extent that people want to change policies, they've got to do that through their legislatures.
I want to end finally with looking to the future and policies and programs that may be forthcoming or upcoming. But there's some good questions, so I want to get to a couple of these now. And so if anyone has more questions in the audience, please put them in the Q&A now. One audience member asked, to what extent do prosecutors who are making prosecutorial decisions on a case-by-case basis need to have some prosecutorial policies to ensure or to protect themselves against claims of bias and discrimination? I think, Lou, that's a good one to start with you.
I think prosecutors are giving, prosecutors' offices, the size of prosecutors' offices in Ohio vary widely. So I think prosecutors at a minimum are giving guidance to the people who work for them or have their own notions about how to charge cases. The risk, I think the risk that some of these progressive prosecutors run with the policies that they've put in place is that you're tying the hands of the people who work for you in a negative way. It was, I think, Larry Krasner who said the prosecutor is just a public defender with power. And I have a problem with that. Yes, prosecutors are ministers of justice. They have responsibilities to the defendant to ensure that they're treated fairly and that their rights are upheld. But they have a responsibility to their communities and to the victims of crime too. And quite frankly, we have an adversarial system, and the prosecutor's responsibilities should be first to the victim and to the community. So I think you run the risk of, when you put policies in place like that, that you're going to tie people's hands. And I guess I'll just leave it at that. We want people to be treated fairly. We want people to be we want some sort of unanimity or equilibrium in the way that people are charged. But I think the problem with that is that every case is different. And I think when you're looking at the facts of individual cases and the criminal history of individual offenders, prosecutors need to have some leeway to decide what to do that putting strict policies in place might not allow.
Yeah, I guess I also heard maybe that there was a question about liability for prosecutors, and Louis, I don't know if your association provides like insurance. I mean, generally, the idea is certainly prosecutors shouldn't be able to be sued for making an honest mistake, and they can't be. It reminds me of, in Washington state, where it's an unusual law they have, but basically a probation or parole officer or the government, you can get damages from them if somebody recidivates in certain ways and you're a victim. It's very unusual, and so the consequence of that is they don't use probation and parole very much, which has its own problems. But on the other hand, certainly we've seen instances, it's very rare, I think, but where prosecutors, there was a rogue prosecutor who intentionally hides exculpatory evidence, and the key word is intentionally, right? And I do think there ought to be recourse there, both from a professional disciplinary standpoint and from a potentially, obviously, having that individual removed and even collecting damages either from them or the government. But again, that's a really high bar, and thankfully I don't think it's common, but there have certainly been high profile cases of and it's just like police abuse, right? I mean, a small number of prosecutors or police can bring discredit to the larger profession, which is an honorable one if they're not disciplined and held accountable. But I also saw there was one someone also had a question or comment in the chat. I think Matthew brought up some of the research that did show there have been some empirical studies now that have shown in Boston and other places that not prosecuting certain low-level misdemeanors, especially if they're low-risk defendants, that those who weren't brought through the formal court process ended up being less likely to recidivate over time. And that gets to the point that some of the ways we hope, some of the penalties we impose in the justice system in terms of obviously having a permanent criminal record that make it harder to get employment or housing, some of those collateral consequences make it more difficult for people to kind of follow a successful path going forward. And so it's a delicate balance, because obviously the public rightfully wants consequences, especially for conduct that harmed, someone's property. I mean, obviously we're talking about low-level misdemeanors. We're not talking about violent crime. So, that's where a lot of these off-ramps from the justice system are so important, and where the prosecutor can play a role, again, individualized to each case, but trying to see, okay, before this person sits in jail for weeks on a $500 bail they can't afford and loses their job, maybe they can't pay their rent, so they're kicked out of their apartment, their car's impounded, all these bad things happen when you sit in jail. And then, obviously having a criminal record is really detrimental. So I do think prosecutors kind of, many of them are playing a really important role in the kind of off-ramps from the system at different points, depending on the severity of the case. And again, obviously there's cases that need to be prosecuted all the way through and people who need to be incarcerated. So it's a very wide spectrum of the types of responses that prosecutors need to be prepared to provide.
A follow-up about discretion. What about leading on grand juries and prosecutors who say that they'll only prosecute if a grand jury indicts? Mark, do you want to start, or Lou?
Well, in Ohio, you have to have a grand jury indictment to proceed on a felony. So I think that's a non-issue here. You've got to present it to a grand jury, and they've got to issue an indictment on a felony case.
I guess where this has come up to some degree is officer-involved shootings. We've had district attorneys like Kim Ogg in Harris County that's Houston, say that any case involving officer-involved shooting, she's going to bring to the grand jury, even if in her view it's clear the officer didn't do anything wrong and it was self-defense. I mean, I think, to be blunt, it's a bit of a strategy to basically for the elected DA, so that any blowback, politically, they can say, look, I brought it to a grand jury. But honestly, I mean, if a DA thinks the case is frivolous, whether it's a police officer or anyone else, they shouldn't bring it to the grand jury if they don't think there's any legal basis to indict. Now, you can create other processes. There's a concern that perhaps because prosecutors work so closely with police on a daily basis, you should have the attorney general, or you should have somebody else, a special prosecutor or whatever, handle cases involving police officers. And I think that's something we need to look into more. I don't know that there's enough evidence that on this topic. I'd certainly like to hope prosecutors can bring an independent lens to these cases. My concern in some jurisdictions, I know there's Tori Berber Salazar out in California. She's documented, she was under enormous pressure from police unions in terms of their role in trying to defeat her. And she nevertheless really, and it was because she really brought an independent view to these some serious cases of police misconduct. And so I do worry about that influence of public sector unions in this area, and I think it's doing rank and file officers a disservice, because the vast majority of them do a great job.
Thank you. All right, in the last 5 minutes, we want to talk about looking forward, and also some proposals that have been set that Mark, in your notes leading up to this, said might be problematic. So things we started with: prosecutors who are refusing to prosecute laws. That if that's a problem, what are proposals to solve that problem? And Mark, do you want to start with some of the comments you made in our prep?
Sure. Well, we've already covered obviously the recall, the removal, and of course the impeachment, which Larry Krasner has been facing, but it's not going to happen. It needs 2/3 in the Senate in Pennsylvania. So the thing that's actually more perhaps common is to see laws being proposed, and I know I think bills already introduced in Texas on this and other states, Missouri, that would remove, that would say that an attorney general, the most common version is to say, either for a specific prosecutor, like just say Lewis County or just Philadelphia County, the attorney general could prosecute any cases that they don't pursue. And then there's one in Texas that would say also a neighboring, the DA in the next county over could go ahead and prosecute any case that this prosecutor doesn't bring. And so I do worry about that, especially targeting certain counties, because, their voters and elections should have the same consequence as anybody else. But the other thing more broadly is simply that, if somebody is cleared of a crime, they can go back, to their life and don't have to have it hanging over their head. But if there's, other entities that can then prosecute them for the same crime, then it really kind of, I think, makes things difficult for individuals who may have done nothing wrong. And, the other thing is, of course, discretion. Like, to me, if you don't have the discretion not to prosecute, then you really don't have discretion, right? Because if somebody else gets to second guess you every time, then your role is necessarily undermined. Now, I do think, in terms of like organized crime and, schemes that cross county lines and things, having attorney generals also have the power to prosecute certainly isn't unreasonable. But I do worry that these proposals, and it's a one-way ratchet, right? Because nobody's saying that a prosecutor's decision to prosecute could be vetoed by the attorney general, or vetoed, let alone by a neighboring prosecutor. So I do worry it's a one-way ratchet just to more prosecutions as well.
Lou,
I'll just add to that I don't think there are really any discussions going on in Ohio right now about expanded processes for removing prosecutors from office. I certainly hope that there will be restraint on that, and I think there are some good reasons for there to be restraint. I think, and we've had this discussion about whether to give the attorney general jurisdiction over things that our legislature doesn't want county prosecutors to have anymore in the past. And I think that the speed bump to that, the thing that I think gives the legislature restraint is that you might not always have an attorney general who agrees with your position today. I think we've got to be careful that we're not robbing Peter to pay Paul. You give the jurisdiction to a neighboring county prosecutor or to the attorney general, and 10 years from now, you could wind up with the opposite of what you were trying to achieve. And so I think there are some built-in mechanisms that hopefully lead to restraint there. And just the final thought is that it is a slippery slope. When you start to remove prosecutors for if you start to remove prosecutors for deciding not to prosecute one set of crimes, when do you start to remove them for not prosecuting another set of crimes, or prosecuting too many of another category of crimes? So checks and balances are important, but so is restraint. I'm hopeful that we've got a good balance of that in Ohio.
Fantastic. Well, Mark and Lou, I so appreciate everything that you said today and taking the time to present to us. Thank you so much. Thank you, everyone, for being here this afternoon. Everyone, have a great Tuesday. Take care.
Thank you. Thanks all.